Hey, how are you?
Good. How are you?
I'm doing really well. How is your foot, boo boo? How are you feeling?
Well, I'm coming along. I last week I started doing more walking inside my condo, and then I transitioned to that big boot. Um,
Mm.
when I've gone out.
That's what I wondered. How is she liking, how do you like wearing that big boot?
Now I still have the scooter. It's on loan from a friend, but I'm actually driving to San Diego this afternoon and spending a couple days, and I fly out on Wednesday. And so I'm going to
Oh,
get airport assistance, with the boot, but for
yeah,
the
to get you onto the plane. So are you flying for fun or are you flying for work, for a presentation or?
for fun.
Oh, great. Where are you going?
No, South in North Carolina, and I'm meeting
Oh,
up with a couple sisters and a longtime friend from Santa Barbara, and we're going
oh,
to go to Andy of Mayberry, quite honestly.
wow. Oh, how
Yeah,
fun. Well,
yeah.
I don't, it was a while ago, but Bill and I did a drive through that whole Smoky Mountains,
Blue
that
Ridge, yeah.
whole thing with Blue Ridge Mountain. And it was really fun. I didn't think it was going to be that beautiful. It was really, really beautiful.
Yeah, I talked to my sister on Saturday, and she said, "Oh, and was we were talking about plans, and I was asking about weather, and she said, "Well, the weather is actually supposed to be totally sunny, no rain expected. It'll be in
Yes.
the low 70s during the day, but it will drop down to the 40s at night. So I'm having to plan clothing accordingly,
Yes.
and
Sweaters. Yeah.
yeah, and so it was just yeah. So, but she was talking about just how beautiful it is, and
Well, and
there's
you're
that
going to get the
festival going.
fall colors, right?
Yeah,
So yeah, that's super. Oh, I'm super happy for you. That's a
yeah. So I'm
fantastic
looking
trip.
forward to it. Yeah, I've,
So you can walk on the trip. You just can't walk a lot. You're saying you could walk a little bit.
yeah,
You
yeah.
guys will just have to kind of take no hiking for you.
No, no hiking.
Yeah,
No.
taking it easy, right?
Yeah, yeah. So I actually I go back to my fourth post-op tomorrow, and
Mm.
yeah, because I thought I'd be in that big boot much earlier, but he says no. I really want to see you stay off your feet. So I have. I mean, I've used the scooter all month for 6 weeks,
Hmm.
but I just was feeling better, and although I've never really had pain.
Yeah, you haven't had a lot of pain. This is a lot of people really experience a lot of pain with
That's
it.
what I've heard. Yeah. And I
Oh my
go, I really
gosh.
haven't. I mean, if anything, I've felt more tweaks. Well, for two reasons. One is that, I'm still gaining neurological functioning in the ball part of my foot. So I'm feeling things a bit more. But
Oh, you
second,
were numb for a lot of this. Mm,
yeah,
makes
yeah.
sense. Yeah,
But
that
then,
makes
but
sense.
then wearing the boot, is that, so it actually, yeah, but I've gotten a little bit better used to it. So anyway, I might when I land in Greenville, I've looked ahead, and I'm going to talk to my doctor about should I rent a scooter while I'm
That
there.
was what I was going to say. Are you going to have a scooter there, or are you going to just kind of do your best with?
I was going to do it just with my boot, but when I'm thinking about it, because it's like even tomorrow, I think I wasn't going to, but I think I'm going to take the scooter with me because just going from parking lots to the offices, and I'm
Mhm,
actually going to be moving around later today, and I've got appointments tomorrow. So it's just like, that's a lot of walking,
mhm.
you know?
Did you keep the boat at the yacht club, or did you move it down to where you are?
Oh, no, it's still at the yacht club. I'm still a
Okay,
member
I thought, oh, I
there.
wonder if she left her boat. I didn't know if they had a place down where you are to put it at Rosarita. I
Yeah.
wasn't
I'd
sure.
have to go all the way to Ensenada.
Oh, that wouldn't be convenient. Yeah.
Yeah. I
Okay.
mean, I'd almost be better going back to Coronado than
Yes, than doing
that's
that.
an hour plus, so
Yeah.
yeah, so anyway, I'm coming along,
Oh,
and
I'm glad. I'm glad to hear it. And I'm glad you're going on vacation. It's
yeah,
beautiful. Fall's a great time of year to go back there, right? You're going to see all the changing of the colors and the changing of the leaf. And then it's before it really starts to get cold, right? Because
yeah, yeah. So I'm excited, and yeah, so I guess we probably should talk a little bit about our program today. So
I did.
Uh,
It's so funny. I was telling Bill, I save all the articles so I could go back and research them for real before we do it. But I had a devil of a time. And then I couldn't find where I saved them. So literally, Deborah, last night I looked for them for like an hour, and I did finally find everything and did all my research. But I need to put them like in a folder because
yeah,
it's another month again before. So I
yeah,
collect things for a month. Then I can't find the ones that I want
yeah,
to read.
yeah,
So I
yeah.
was like, oh
Well,
my.
what I because I've done that too. I ended up calling different things. The things I use for our podcast is I actually put it into my Q&A podcast,
Gee,
and then I put it
that's
according. Yeah,
genius, right? You know what
yeah,
I do? I just save it in like important documents. Well, there's a million important documents. I had to open
yeah,
them all last night. I was like,
yeah,
what's the four that I need? I only need five things. How hard
yeah,
can this be? But I
yeah.
told Bill I have to come up with a better system.
Yeah, yeah, yeah. So it works better for me, and because and I'm so glad you sent me back the article I sent you because it's like
Well, I sent
I
you
pulled up a
back.
different one.
I
It's like
didn't know if you wanted to link the DMEC update and the Ask Jan article.
yeah,
So I thought, oh, I wonder if she's got them. Since I found them, I'll
yeah,
forward
yeah,
them to her in case she wants. I didn't know if you wanted to include them.
yeah. No, I had already planned to do that, and so alerted Raymond to that. So I'll just
I thought,
follow up
well, I
with
wonder if
him.
we threw everybody off with changing the time, or we'll see. We'll see
Well, I
if.
did see because I get email notifications when people try to log in, and
Mhm.
somebody did try to log in 11. And I thought, oh, I'm confident I changed that. So I looked, and sure enough, it said 1 o'clock. But you know,
Oh,
I'm thinking, maybe this might be a better time. I don't know.
we'll see. Mhm.
Yeah, yeah.
Some
Although
go to
quite a few
lunch
people
around
did,
this time.
yeah, quite a few people did register,
Okay.
and yeah, even as early as last Wednesday when the notice first went out.
Because we usually
And
do it before lunch. Now we're doing a little after lunch. So I thought, oh, well, it'll be an experiment to see
yeah,
whether, this is a good time. I know they're like crazy busy. I spoke to HR at the county office on Friday to their little group, which is really a great group because a lot of the newbies were there. A lot of the people that you and I know and work with were there, but a lot of the
oh,
newbies were there, like Armando from and it was really interesting. So
hmm,
because
okay.
I had that challenge of do I go more intermediate advanced or do I go beginner level? And I thought
Mhm.
I've got to go in the middle and just use a lot of examples because
Yeah,
I could see in the audience I had both like this,
yeah,
right?
yeah,
Way up here and then people that just started that don't know anything. So
yeah, yeah, yeah. I when I get back, and now that I'm getting my foot behind me and Snickers behind me, I was so busy, for so many months, and then I was doing some expert witness work this summer, thinking, oh, it won't be too busy, but it still was until finally last half of August and September really dropped off. But I forgot to follow up on contracts and stuff, and so it's like, oh, I
mhm.
still haven't done that. But
Do you do your
oh,
contracts July to July? Same thing, July 1 to June 30. So do
yeah,
you have to renew all of your non-industrial contacts on July 1? So do you have someone to do that for you or do you do that?
I've been doing it, and I just
You've been
totally
doing it.
forgot about it.
Do you, because you
Yeah,
have quite a few of them, right? You have.
yeah.
Mhm.
But this is maybe you can write yourself a note. I never did get an updated list. You sent me one, and then you said, "Oh, wait a minute, let me have my staff look at this because so many of the people have changed, and I
Yeah,
never did get it." And I
I'll
think I was
send
waiting
you.
for that, and then out of sight, out of mind.
Okay, I will do
Okay.
that.
Yeah.
Make a note.
Yep. Yep. So, well, very good. Very good. So I'm pretty much sort of taking the first couple, right? And then you're gonna
Yeah, I
just sort of,
figured you'll take the ones on the updates on the ADA timeframes and
mm,
then the what about the medical
medical.
documentation. And
Mhm,
then I
mhm.
researched the EEOC case where they're setting their sights for enforcement
Great.
going on in the future.
Mhm.
And then I have the second EEO. I have two cases and then I have kind of like a overview of what they're sort of focusing on or what they're
Yeah.
going to be focusing on for next year.
Yeah. And I just have had an interesting one. It's for the Boys and Girls Club. And the employee had a stroke only in his 40s. It led to a visual impairment. It's not vision corrected though, because it's in the brain. And so that my sister-in-law went through something very similar. So I was familiar with it. but he's only got partial vision, and he was a site supervisor. And so we had a meeting, and we talked about, a trial return to work, doing a walkthrough first, getting a job coach, to assist him to see what could come up. And apparently he just had a conversation with the director over the weekend, and he's concluded that he can't go back to that work.
Not gonna
And
work.
so and they go, well, what do we do? And I said, well, I think, my recommendation, doing a follow-up IPM, because we had mapped all this out. It looked like it didn't go anywhere. But if we document all this, then he can use my summary to then go to the next steps of whatever disability services he's going to need.
Right. If he goes to disability PERS or SSDI, wherever he goes, he has that document, which might really help.
Yeah. Well, and I've had clients who've done that all along. So it's nothing new.
Well, Sean reached out from Grossmont because he got a document from STRS, and he said, what is this? And I said, this is STRS disability. And he said, Athens needs to fill this out. And I said, no, went to the principal. I said, this is for you or the supervisor to fill out on why can't you accommodate? He goes, well, we already had the IPM meeting. And I said, well, that's a great thing to attach, is the IPM summary, but you still need to answer the questions. It's a form, and the people cannot get disability STRS or PERS without this form. Because he was like, I've never seen it before. And I said, I've seen it before, but we don't fill that out. That's an employer.
That's an employer.
And I said, it's what did you try to do? And why can't you accommodate? That's what they want to know. And your IPM summary, to your point, is a really good underpinning. What did we do? What did we discuss?
Yep. So, okay, it's 1:01. We have 3 people in the room. And
I just finished 6 hours or 5 hours of POWI interviews, Zoom back to back. So
wow.
I'm well familiar. I'm totally on Zoom today. I'm a Zoom girl.
Wow. Okay, let's see. I'm just checking things out here. Okay. Yeah, I've got a bunch of things up on my screen, so it's like, okay. I just had the participants. Oh, there it is. Okay.
Yeah, don't you love it when they're there and then they disappear and you're like,
yeah,
where did they go? They were right here. They literally are gone.
Oh, one more minute. Who is Linda McCain? I can look it back up in the email. She was the one that actually came at 11 o'clock, and I thought, I don't remember her name before.
Oh, because you're saying, well, because 11 is our normal time. So that you're right. I'm trying to think about what school district, unless I know you have some private employers that you send the invite to too. Some other clients that. But yes, I love the Ask Jan little format. And I also love the little DMEC. Theirs is a Q&A, Ask the Expert. But both are very nice.
Yeah, I did the DMEC.
I don't get those regularly. So
and that's why I've been sending them to you.
Great.
Yeah. And I had actually done that whole Q&A thing. They set you up for a month or something like that. And it costs quite a bit of money, though. It's like $3,000 or $4,000 to be part of that.
Oh, to do it.
Yeah. And I sort of, I tried to get more disability related, but they have Tracy Freitas from Jan, who's been there forever. I mean, she's been there since I started working in Boca.
Right.
And so it's sort of hard to compete with somebody from the horse's mouth,
Yes,
so,
for sure.
Yeah. Okay, I'm just looking at a couple of them. Oh, EUSD, would that be Escondido?
Yes.
Okay.
Oh, that's the new gal that's filling in for Victoria.
Okay, Victoria's here too.
I was going to say Linda is the new Victoria, or she's going to be when Victoria leaves. So she's learning. She's very, very much learning. I haven't even met with her. I have to reach out to do training. That reminds me to do that.
Okay. Yeah, and I haven't reached out to Victoria also about her moving to Palomar. Hopefully she'll start using my services there.
Yeah. She's going
So
to
I'm
be
letting you in
in
right now.
HR and work comp, right? Good morning, ladies.
Good morning.
Good morning. How's everyone?
Doing well.
Well,
So,
go ahead.
yes, I was going to say, I'm going to introduce you.
Yes, Linda is the new you, Victoria. Is that who?
She's the new interim me, so maybe she'll show you her face.
That
Linda?
would be nice.
Sorry, I don't have a camera.
What?
Oh,
Oh,
Oh
Yeah,
my
I don't
gosh.
have one. Otherwise, I would.
Oh my gosh.
Maybe
okay,
the
Linda.
next one.
Yeah,
Yes.
nice to meet you, at least in
Huh?
the virtual world, Linda. I will come
Thank
out. I'm
you.
going to come out and set up training with you. So thank you.
Awesome. That would be great.
Great. Yeah, I look forward to meeting you too, Linda. Because yeah, we oftentimes do use Zoom for our IPMs unless sometimes we have more critical needs that it's better to meet in person. But so I do in-person ones upon request. So
Oh, great. Well, thank
And
you very
Beatrice, I
much.
apologize. I saw your phone calls coming in and I was on an interview panel and that lasted, I was telling Dr. Dupree, I was on there, I've been on Zoom for like 5 hours or something. So I
Wow.
am going to call you as soon as
No worries.
great.
Well, it's
Well,
nice
welcome.
meeting everyone.
yes.
Well, great. Thank you. Welcome aboard. And we have a few other people who've joined us. So, hi, Megan.
I'm
How are you?
Megan from Carlsbad. How are you?
Yeah. Great.
Thank
Great.
you.
And we have there we go, Roy Braun. I was just
Roy.
going to say your name. Yeah, yep. And
Roy, that
Vincent.
was very exciting that I got invited to your breakfast recognition. I thought, I have worked with Helix for 15 years. I've never been invited to this breakfast, but is this something you guys do every year?
Well, I don't know because this is my first year here. But my understanding is that it's gone on for a while with the pandemic. They stopped doing it, so I think this is the first.
Oh.
No, wow.
Well, it was a big honor. I thought, ooh, how fun. I've never been invited to this before. Obviously, well, it looks like it's a lot of fun, right? You have music, you have
Oh, free breakfast, right?
right, free breakfast with music from the school band too. So it's very exciting.
Well, very good. Very good. Well, we want to get going. We want to be respectful of your time. We would like some feedback from all of you, though. This particular month, I needed to change the time because I'm involved in another program for next week, and we were going through all of the control settings for next week's virtual conference, and so that was the only time I could do it. So, but we were thinking, Felicia and I were commenting that, well, maybe 1 o'clock's a better time. I know I didn't feel so rushed this morning, not having to be ready by 11 o'clock. So we'd like to have your feedback if 1 o'clock might be a better time on Monday. Okay, so keep that in mind, because we'll have a couple more for this year in November, and sometimes in December, depending upon what's going on, we may or may not. Usually we go dry in July and sometimes in December. So we'll see how that's looking. Okay. Well, thank you, everyone. Again, this is being recorded, and for those of you who have registered, a link to the recording, along with some supplemental materials that we referenced, will be sent to you too. There's a great article from the Job Accommodation Network on accommodations, temporary and long-term. And one thing you'll see, and that's why we're bringing up some of these topics today, is that, like with many things, there's an evolution of thinking. And the article particularly, and I'll get to that in a bit, but talked about how the original ADA did not define disability the same way it's now defined with the amendments in 2008. And so that's just something to be aware of. It's an evolution, and that's why it's so important to go back and revisit and see key concepts. And part of that will be about temporary accommodation. So let me just, moving things around here, I just want to go over our agenda so everyone is clear on what to expect. We're first going to provide an update on ADA, timeframes on temporary accommodations, and that's where we do have a PDF available. And then what about medical documentation? Again, we oftentimes feel we have to have substantiating documentation, but there's some do's and don'ts that have come forth. And I also want to introduce to you during that time an organization that I've been a member of. This is really dating me back to the 1990s. It originally had its founding in San Diego. but has now grown so much as a national organization and one of the most prominent organizations regarding disability management. And then we've got 3 specific cases that are very unique in the sense of what's been happening. And so we're talking about where an accommodation was denied, then terminated with long COVID. EEOC is starting to address, the AI, particularly in the use of human resources and how employees with disabilities are considered vulnerable. And then the big one is that there's a case going before SCOTUS, Supreme Court, regarding a UPS driver that we talked about briefly last time. And so we'll be covering that in our ground today, and we'll plan hopefully be about 30-40 minutes. And Roy, I saw your question in the chat box, and so we do a follow-up with recording, and then that's where we'll include the links to these documents that we're referencing, because these are things I really feel, particularly the one on accommodations, is important to take a look at. Okay, so with that, we will begin, and please do ask any questions that you might have. So the first one that came up, and this was through the Disability Management Employers Coalition, or what's called DMEC. And just so you know, in case you want to, I was part of the origins of a certificate training program back in the 90s, and it's called Certified Professional in Disability Management, CPDM. And so that really takes you through a wide variety of aspects of managing employees with medical conditions. And so it might be something that you might be interested in as part of your professional development. But DMEC is the one that originated here in San Diego back in the 90s. And so what they do every month is that they have what they call Q&A Fridays, for example. They have other articles that will target certain topics. And in this particular case, they addressed medical documentation. And so what it does is that they can, employers can actually post questions, and then those questions may be addressed with a very specific answer. So I'm going to read the question because I think it's important to understand the context. We require that employees with disabilities provide medical documentation from an appropriate healthcare provider to substantiate the need for an accommodation. And then it goes on to say, what we're finding is that it's becoming increasingly more difficult for employees to secure medical documentation. And I think, yep, seeing some heads nod. Yep, and I have the same thing. I've been trying to do some fitness for duties, and it's like, oh my gosh. Mm-hmm. And so what the answer is that according to the EEOC, employers cannot ask for documentation when 2 factors, both the disability and the need for reasonable accommodation are obvious. Mm-hmm. Okay. That I think a very clear-cut example might be, someone who's using a wheelchair. Well, yeah,
crutches, right? Comes to school with crutches, right?
Yeah. But the interactive process would still be necessary to say, well, what are your needs for using the wheelchair? What areas of access are you having problems with? We don't need that so much from the doctor. We need that from the employee. The second point is that if the individual has already provided the employer with sufficient information to substantiate that the individual has a disability and needs the reasonable accommodation. And so if you do ask for documentation, it does have to come from an appropriate healthcare provider. So you can't get a chiropractor necessarily to report on an internal medicine condition, or a psychiatrist or a psychologist to comment on an orthopedic condition. It's got to be somebody in the relevant field. And so, but it is becoming more difficult, and doctors are becoming reluctant to provide much in the way of information. And so it is just something to be aware of. I have seen situations of where some employers are adamant about getting, regular updates, every month and to substantiate where somebody is. It's like, well, that's where a conversation with the employee really comes into play as far as how long have you had this? What are the projections? This is temporary, or is it a long-term situation? And I'll go into an example in a moment because I'm actually working with a case right now where an employee, longtime employee, excellent employee in terms of dependability and communication, and she did a stellar job during COVID working remotely. Well, she has a 10-year-old condition that has flared up again, and she's not really sure why. And so she's going through additional testing right now, but she came back with a note saying she needed to work remotely 3 days. Well, the doctor just said remote. The employee's proposal is that she work remotely 3 days a week and then be on site 2 days when her presence is absolutely necessary for certain essential functions. And again, she's hoping it's temporary. So one of our focal points in the IPM last week is that this is a temporary accommodation because many employers are moving away from the idea of remote work because of the impact on the organization. And it's also consistent with the medical timeline that's provided. But then I sort of rounded it out by saying, because, you know, if we need to be fair in our application of the process, and so if somebody realizes that, yes, you have a temporary medical condition for which you need accommodation, we're not opening the floodgates for everybody else to start, requesting remote work, which then could be an undue hardship for the employer. And so I'll come back to that a little bit more when we talk about temporary accommodations. But again, be mindful of the documentation, and sometimes it may be necessary. I can think of, I'm sure you can, Felicia, too, think of tons of cases of where, the employee claims the medical condition, but there's no substantiating documentation. So we have no idea of how to accommodate, but it is a burden on the employer and the services to students because the unpredictability, unpredictable nature and the duration of the medical condition is totally unknown.
Right. Well, just last week, I think this was non-industrial condition. They fractured their leg or their foot over the weekend and just showed up in a special ed class, like mod severe, with crutches, with, the kids running all around. But there was no discussion with the supervisor, didn't bring a note in, and somebody said, well, wait, whoa, wait a minute. Are you asking for an accommodation? How long do you need the crutches? Do you have any other accommodations with the crutches? We didn't even know that you had a fractured leg, right? We need to talk, right? Before you come into the classroom, because they just kind of thought, well, I'll come in the classroom. They didn't even ask the doctor. So they didn't have a note because they didn't even think about and you and I both know how hard it is on your shoulders, right? To crutch around a campus. Do you have small people underneath you that could knock you off your feet, right?
Yeah. Particularly something like crutches is, it's pretty obvious, but at the same time, it can actually be a safety hazard in the workplace because of the instability and having many people around. I have heard of instances of where in a special education class that students have grabbed the crutches out from the person and then used them as a tool, shall we say, in aggression towards others. And so all of those things need to be taken a look at. And I know I had another situation too, where the employee is limited in walking, and yet because of the strain getting from her car to the site, it's a large campus, wanted to work from home too. And I said, well, wait a minute, there are other means of mobility than crutches to get from point A to point B. And let's talk about a motorized scooter or something on a temporary basis, which alleviates, because it is sort of a hardship for her to work remotely. So, yeah. So just, again, be mindful when we're talking about medical documentation, and always make the request, unless it is something so obvious, that you don't need it. So just a word of caution, again, thinking a little bit differently about that. Any questions so far?
I just wanted to add on that too, that a lot of times their primary care physician, even though the district will say, well, I'm not going to accept this note because it's from the primary care physician, and it might be a non-industrial or perhaps an industrial mental health stress claim that hasn't been accepted yet. And sometimes, as we all know, access to care for mental health is is difficult. And so you know who treats them first is their primary care physician may give them an off work note or work with limitations and put them on antidepressants. They're perfectly capable of doing that. And at Kaiser, that's very frequently what you'll see, right? That they start there while they're working them into their program that they have to treat anxiety and depression. And sometimes, so those notes also need to be taken into consideration.
Yeah, very, very good, very good point. Yeah, so now the next one was talking about, I guess I just flipped the order here, I apologize. I talked about medical documentation first and then the updates on the ADA. And this is where there's been an evolution of thinking from when the ADA was first passed in 1990. We didn't even think about employees with work-related medical conditions. We were thinking about the more obvious ones like visual impairment and hearing impairment and mobility impairment. And yet now we know, and particularly after COVID, that there's a plethora of medical conditions that can come into play. And just so you know, is that the original ADA did not even address what happens when you have a temporary medical condition that needs temporary accommodation. Inclusion of that didn't come about until the amendments in 2008. Now, I'll say I used to be in vocational rehabilitation, that we did temporary accommodations all the time, for work-related purposes, for work-related conditions. And so that was a rule of practice in voc rehab. So it was odd that the ADA didn't include that, but from a best practices standpoint, we just kept doing it anyway because it made good sense. We know that people oftentimes will recover better and faster, and there's less of an undue hardship on an employer. And so what this article goes on to say, and this is one we will provide, is that, again, the idea about providing a temporary accommodation while researching a permanent solution. So this is where, for those of you who have worked with me, I talk about, let's do a trial, let's do a test, let's do a trial basis for this accommodation to see if it even works. We don't know, and so that was one of the things that the article addresses too, is, to try things out. If it means helping keep someone at work, so there's no loss of pay, and there's meaningful work that can be done that meets the needs of the organization. The other thing about temporary accommodation is to explore whether or not it's effective. Because remember, the language is, providing accommodation, readily achievable, effective accommodations that enable an employee to perform all the essential functions to the level of productivity required in the current business climate. That's the spiel. And so, oftentimes people may request an accommodation. In fact, I'm an expert witness on a case right now where, you request an accommodation, but it wasn't realistic. And it did not take away from some underlying complaints that other employees had. And so it's got to be effective. It actually has to help someone perform the essential functions. We like to say in this field that, an employee can request a Cadillac, but guess what? They get the Volkswagen if the Volkswagen will help them get the job done. Okay, so it doesn't have to be the best, most desired accommodation. It just has to be achievable and effective. And so the ADA, as amended, now does address that, hey, it makes good business sense. If somebody can return to work through a temporary condition, through temporary recovery, why not? And because one of the big things that drives all of this is that we don't want to impact someone's ability to earn a living. Because if they can't earn a living, then guess what? They do go on to other disability roles that then cost the taxpayers even more money. So it gets all tied into, I did a big research project on this a few years ago. So it's all about keeping people working. And the timeframes under accommodation I've been finding this out lately. In one particular school district I work with, I can't find anything that says this, 180 days max. And it's like, wow, that's just been the way it's been practiced, ever since the ADA was implemented, and there's some court cases in the early days. And so it looks like there still isn't anything that's specific. Although
no definite guidelines, right? Which just makes it so hard.
Yeah. But this is where we can do some extrapolation, though, because the ADA does say that if a condition is 6 months or less, hence 180 days, then that's doable. Okay. But longer term accommodations, they have to be readily achievable. They they should not provide any direct threat to the employee, and they should also not provide an undue hardship. So you can provide a temporary accommodation, but that doesn't guarantee that it becomes a long-term accommodation, particularly if it presents some undue burden for the employer. And so that's something I oftentimes will say when we're talking about temporary accommodations, is that this is temporary. Once you reach maximum medical improvement, we have to reevaluate this. This is only temporary.
Right, we're having a different discussion then, right? Are we going to be able to permanently accommodate you and offer you a modified or alternative job or not? That's a different conversation, right?
Yeah. And so I think the bottom line on this is that there are some things that aren't so hard and fast as we may have suspected. Again, the ADA does include the opportunity for temporary accommodations. And again, I'm using that 180 days. And now we know that many school districts have bargained into their union agreements about the 60 plus 60 or the 90 plus 90. So there is some foundation for that already having been negotiated. So it's consistent with the overall thinking, because as the EEOC has said in past rulings, temporary accommodation up to 90 days, is not easy for an employer. And I say this a lot in my IPNs, it's not easy, but it is doable. Almost any of us can tolerate things for about 3 months. But when you go beyond that, that's where it becomes more challenging. But when you get to 6 months, then it's you either make that a permanent part of the future, or we have to re-examine the undue burden and the effectiveness of doing all the essential functions. So I always go back to that as to thinking behind this.
Yeah, I think that's good. And I think too that many or almost all of the districts have their own policies, right, about timeframes, and it varies district to district. And some of them reset those timeframes for certain extenuating circumstances, and some do not. But you're right, there is no hard and fast rule, right? Other than you have your policies, and then you have to, work on that reasonableness. And I think one of the things, the big takeaway that we always hear is that undue hardship is a rare argument, right? It's not very often that you can really argue, oh, we can't do this. This is an absolute no-go. So then when you're looking at temporary accommodation, there's a lot of things that you can do, right? Yeah.
I do want to say one more thing again, where we've extrapolated regarding this accommodation thing and hard and fast rules. It was sort of a different kind of setting, but again, it reflects the EEOC's thinking in that there was an employee who had been off for almost a year. The employer had a hard and fast: if you're not back to work within a year, you're terminated.
Right.
And the employee did reach out to her employer and said, I just need another 30 days. We're almost there, but I'm not going to be quite ready to come back to work at exactly 1 year. And they said, nope, fired her. And so she took the case up, and so the EEOC did rule in the employee's favor, saying, and basically the language is that if there's a request for a finite, a time-limited extension, and they actually used, like 30 days or even 60 days, and maybe on a case-by-case basis, another 90 days, but that would then be 2/3 of a year or 3/4 of a year someone's out. But and that's doable. But when we get language saying this is indefinite, no. So that was a couple of years ago. So we can extrapolate, from that as far as, okay, yeah, we're supposed to not go over 120 per the bargaining agreement. But again, if it's a defined, short extension of time, but then I usually say, but we don't want to exceed 180. But there have been exceptions to that, case by case basis. So,
right.
Yep.
Makes it hard, right?
Pardon?
Makes it challenging, right?
Yes, it does make it challenging. That's why it's so important to come together and get other people's perspective about, cases. And that's where I know many of you call on Felicia. I'm also available just to, what do you think? Let's take a look at this from somebody else's perspective. So, okay, well, let's go into the couple of these specific cases because they're so interesting. Tell us a little bit more, Felicia, about the appliance store.
Yeah, so I picked a few different ones today that I thought were interesting. The first EEO case is a appliance store that denied an accommodation to and then terminated an employee with long COVID. And the EEOC found that violated the ADA. So the EEOC filed a lawsuit in this case, and the employee worked for the appliance factory in Colorado. And they began experiencing symptoms with long COVID. And she was working with HR, and she asked to take her 12 weeks of FMLA, which HR said, okay, great. And that was set to expire in June. She had started having symptoms and was off work as of March. In the days, so this is 3 months have gone by, right? In the days before her return, the employee requested a short extension and provided a doctor's note. Could she be out until she scheduled an endoscopy because they wanted to address some GI internal complaints that were related to her long COVID diagnosis. And HR's response to that request and note, they told her, you need to get back to work or you need to resign. Those are your two options. And the employee was terminated the next day because she said, I'm not ready to come back to work. I'm having this test. I need a little short period of time to address this issue. And the company said that her endoscopy and GI symptoms were unrelated to her COVID diagnosis that caused the FMLA leave. And that is why EEOC sued, right, Deborah? So you could kind of see the red flags in there, right? There were several points where you would have stopped and made some phone calls and made some other decisions, right?
Yeah, that would be where it's really important. Again, is I mentioned I'm on expert witness on a case right now, and the employee is claiming the employer failed to engage and or provide an accommodation. And so, you know, I'm still trying to understand the employer's process, but it doesn't seem, he made a request and they just said, no, wasn't reasonable. And it's true, it wasn't reasonable. But it does, I haven't found in these thousands and thousands of pages I'm having to review where they actually had a conversation. And I mean, they did have one, but they didn't really explore, well, how else could we go about this? It doesn't appear that there was any consultation with Jan and things like that. So just again, stop, pause, assess what the situation is, reflect on your options, and then make choices.
And be careful when you're pretending you're a doctor, right? Because we don't, that statement that the GI symptoms were unrelated to long COVID, if you're not a physician, that's not a conclusion that you're qualified to make as HR professionals, right? Or risk professionals. That's not actually in your area of expertise, right?
Yeah. It's really more about, okay, obviously there's medical conditions, whether or not they're related is not our decision. It's what accommodation is necessary to deal with this. Yep.
And it really was not so much an accommodation request as leave, right? Leave after the FMLA. And they were like, no. And you're right. They didn't have a discussion. They just said, you're coming back to work tomorrow or you're resigning. And the person didn't want to do either of those things or couldn't do either of those things. And so they fired them, without any meeting, without any discussion. So these are all good learning experiences, right?
So employer beware. Okay, so number 4, EEOC is looking at AI and biases.
Yeah, so it's interesting. They set out, EEOC has a strategic enforcement plan that they have to do. And so they developed their plan for 2024, the things that they're going to kind of be looking at and setting their sights on. And one of the areas that they're looking at, there's a few different areas. One of the areas that they're looking at is a lot of HR departments are now starting to use AI to assist them with their sorting through applicants and helping them with their hiring process. And they're going to be looking at that AI really carefully to make sure, of course, that there's no bias used, and then to address that. And then they're also, that's in the recruitment hiring area. And then they're also going to look at discrimination against what they call vulnerable employees. And then I thought, well, what is that? And that includes, that includes employees that are pregnant and have childbirth issues, migrant workers, workers with disabilities, LGBTQ, and older workers. So that's kind of the focus. And so obviously our workers with disabilities, whether they be non-industrial or for workers' comp, fall right into that strategic enforcement. So I just wanted to bring that up because that's kind of one of the areas it's looking at that, those classes, those protected classes, and making sure that we're following all our laws and processes with that. And then also using HR departments that are using AI now to help them with their recruiting process. They are kind of looking at that. They want to make sure that that's not showing bias, just like we're not supposed to show bias, right?
Right. Yeah. So some, we're being challenged on many fronts, and hearing more and more about AI, but how, but there were just some interesting things on CBS, I think, this morning about the founder of AI, and both the pluses and then also the minuses. And
well, because underneath it, it's using a data set. But if the data set shows bias, then the AI can show bias, right? So we just have to be careful, right?
Yeah. I know it's going to be a big topic next week at a legal conference I'm attending and speaking at. And one of the things, I just heard this story, again, to show you some of the inaccuracies, because it comes up with wonderful information, but you better double check your sources, because what they found is that somebody had written a brief and the judge says, I don't remember that case. And so it started looking into the facts behind some of the citations, and turned out none of them were real. They were made up in AI. And
isn't that crazy that the AI can do that? It put real judges' names on the cases, but the 5 cases that were cited didn't exist.
Yeah. So very interesting. Well, now this one's a very interesting one. Our 5th topic for today: the UPS driver asked SCOTUS to make some decisions. So take it away, Felicia.
Yeah, this case is going up right now. So UPS driver is asking the Supreme Court to decide whether the company placing him on unpaid leave to accommodate his disability rather than providing modified equipment that he requested violated the ADA. And the underlying case is Hannah versus UPS, and it's on appeal right now to the U.S. Supreme Court. It went to them on 9/15. So this one's very timely. So I thought I would bring it up. Plus, it's a driver. So I thought that was kind of interesting for us too. So the Supreme Court is supposed to decide whether UPS's move, and they placed him on unpaid leave after a meeting about a request to accommodate his disability. And the employee, it was kind of interesting. He argued his request for a smaller truck. So he was still wanted to drive, and he still was going to deliver packages. He still was going to do the essential functions of his job, but he had a back problem. And his back problem caused him to have problems driving the larger UPS trucks, what I call standard size. And that his request for an accommodation was to a different vehicle. And he didn't feel that smaller vehicle would have violated his ability to do the job or any union agreements or interfere with his ability to perform his essential job functions. What UPS said, what their argument back was that his route was busy, right? The route that he was on and the driving that he had to do was a big route, and it called for a larger truck to carry all the packages, and that a smaller truck was not going to serve the route. And so the company said, we're not able to provide you with a smaller truck. They have smaller trucks. They just said, you can't drive one. And what we're going to do is you don't have to return to you're going to retain your job. We're not going to fire you. So that they kind of did that. And then they said, and you're going to be on unpaid leave. Well, okay, we're not going to fire you, but I'm not making any money. So I'm still, I'm still in a real pickle. And and they said, you're on unpaid leave until you can come back to work. So they didn't let him go and they didn't fire him. At least they didn't do that. But they also said, we're not going to give you the smaller truck. And then the employee's argument and why it's being taken up to the Supreme Court. What he said was the company, UPS, didn't provide any documentation on how many packages and why the smaller truck wouldn't work for his route, meaning they didn't do any research into their argument. And they also didn't provide any documentation or any studies on why he couldn't use the smaller truck. Because he was saying, I'm still willing to drive, I'm still willing to do my essential functions. It's just the smaller trucks, I guess, don't bounce around as much. So he felt like the doctor's note was that the impact on his back would be less. And so that case is still under review and will be being decided. So I'll report back on what the end result is on that. But that's kind of an interesting case because they did not terminate him. They did not accommodate him. They said, you staying on the books, you still work here, you're retaining your job. So they must be subbing him somehow. He's still out and he's on an unpaid leave of absence with them. So that's kind of an interesting case too.
Yeah, it'll be interesting to see on where this transpires. So I do see a question in the meeting chat. Do you have any information on SB 553 on workplace violence prevention programs and or plans, and whether injuries sustained by employees at the hands of dysregulated students would be included? The current recommendation is that employers look at hospital medical facilities since they already have been addressing workplace violence in their IIPPs. Felicia, I'll turn that to you. I don't have any specific information on that right now, although I've done a lot of research in the past.
Yeah, I'd have to do some research, and certainly I can follow up on that one, as a follow out to the chat. But yes, did a lot of research for today, but not on that particular topic.
Yeah, okay. So Beatrice,
fine.
look for that to be included probably next time then,
That's a
because
very
there's
good topic to add.
Yeah, there's a lot of overlay between violence in the workplace and then sustaining injuries on work. And certainly we know of the high frequency of injuries that happen from students with some of our behavioral special needs. So
Yes, with
Yeah,
special
this
needs,
is
right?
this is the new it was just signed by the governor, and it's going to be effective July 1, 2024. And it
Okay.
has as opposed to the IIPPs, it has very prescriptive duties that the employers must abide by related to workplace. But I just started wondering if it would address this. In general, the workplace prevention violence is really more geared towards, or originally geared towards, shootings, people coming in and
Right.
threatening employees. But it sounds like it goes beyond that, especially in light of how they referenced the medical staff and the fact that they have already been implementing portions of this, even though it wasn't, necessarily regulated by a Senate bill. So anyway, any information would be really
Yeah, that sounds like a great
topic. Yep. And I do encourage you, just like Beatrice just did, if you see a topic or if you're experiencing a situation at your site, please reach out to one of us to let us know, because we usually will meet and confer about a week or two ahead of time and decide on what seems to be hot topics. Sometimes we draw upon our experiences directly with school districts and cities. And sometimes, we're looking at case evolution, like what we talked about today. And so we're always happy to explore and bring up topics that are of interest to you, and not just what we always come up with. And I just remembered two things, Felicia, that before we wrap up here today, is one, a chance to share with the group here a little bit about that one case I was just telling you about before we started live. And then two is for you to take a few minutes to talk about your upcoming program.
Oh.
Okay. Yeah. So I'll just share with you all that it's not a school district, but it is an organization that provides services out of school district. And they had an employee who was a site supervisor who unfortunately experienced a stroke at the age of 46, and unfortunately has now had significant visual impairment that is not correctable by lenses because it's actually because of the stroke. It's a brain abnormality at this point. And his job, well, much of it, well, a good 50% was more administrative, and we could have come up with adaptive aids, computer-wise and all that kind of stuff. But there's a good portion of his job that was out on site, overseeing staff, overseeing students, engaging and interacting with parents, the need to travel to different sites for meetings and things like that. And we had a really good IPM and came up with a number of ideas, but that was where let's consider doing a trial return to work. Before we even do that, let's do a walkthrough because some changes had happened in the 6 months he was off of work. And then I brought in the idea of having a job coach, somebody who's specifically trained to walk through jobs, to look at things and how they could be done differently for, well, particularly it comes into play for brain impairments. Anyway, I just got an email shortly before we came online for this, advising that the employee and the director had recently talked since our meeting. His leave has been extended again, but he has come to the conclusion that he is not in the state of where he feels he can safely resume his job duties to the level of performance required. And so, they were wondering, well, what next steps does he have then as far as disability? And so I said, we'll definitely come back to the interactive process because then we can adequately document what's transpired since our meeting 3 weeks ago, but then also, document in the written record then about, the employee's conclusion, his consultation with his doctor, et cetera, et cetera. And then that way he can use the employee can use my IPM summary to then take on to other disability services, like if he's qualified for PERS disability or Social Security disability. I've seen that done many times over the years. So
yeah,
bring closure.
That document's very helpful. All the things that were done, and then the employee feels that it's it's not going to be able to be accommodated and is thinking about retiring. As the conclusion.
Yep. Okay, so we've got a big event coming up.
Yes, thank you. I spoke at the countywide meeting at the county on Friday, and I forgot to bring up my own training that was coming up. But on October 18th at 9 o'clock, we have some wonderful speakers. It's in person or on Zoom, so it's hybrid meeting. So you can attend either way. And Dr. Wang is starting from Kaiser on the jobs, medical director at Kaiser. And then we have our account manager from Evernorth EAP, our new ease provider. And then we have 2 of our JPA panel attorneys will be talking about some recent work comp case law. So love for those of you that would like to attend, and any of your staff, obviously, it's open.
Great. And you're wanting registration by the 16th, if I believe?
Yes.
Okay. Do you have a link handy you can put into the chat box if people don't have it already?
I don't. But if anybody emails me, I can get the link over to you if you don't have it. We sent it out to all JPA members, but sometimes it doesn't go to the exact person that wants to attend. So
yeah, great. Okay, any questions, comments from our participants here today? No? Okay. Well, good enough. Well, we will be back here on the second Monday of November. And thank you all for being here. I know a lot of schools are closed today for Columbus Day. And not Roy, I know, not me, not Felicia either, So, but thank you for being here today. And so, Felicia and I will talk about whether or not 1 o'clock might be a better time, but we'd love to hear from you directly. Okay, you like it, Roy. Okay. Megan, I can see you. What do you think? Oh, either one is fine. Okay, great. Well, we'll give that some thought, but I did feel less rushed this morning getting ready for that 11 o'clock. So very good. Well, thank you again. And a couple of announcements on my end. My company has shifted to a new scheduling platform during the month of September. The old one is still available for a little bit longer, but please reach out to me if you're planning to schedule a IPM, and we'll make sure you get onto the right link so you can get familiar with that. Trying to put together a little video overview, so I think it's much easier to use myself. But and then again, remain available for consultation with any questions you have. Both Felicia and I have been at this for about the same amount of time. So I have lots of experience, lots of exposure to different cases and different employer decisions. So we're glad to help you out. Okay. Okay,
Nice to
everyone,
meet you.
have a great October. Happy Halloween.
Day.
Bye-bye. Well, we had a couple of responses in the chat box, 2 to 1 o'clock.
Oh, I was gonna say, did they is 1 o'clock kind of work better?
Well,
Is that
Beatrice said 1 o'clock. I didn't see Linda respond, but
Okay.
Megan, of course, said either 1, and Roy was definitely at 1 o'clock.
okay? All right, perfect. All right.
Yeah.
Yeah, and I'm good for either. I mean, yeah, I mean, I can, as long as it's scheduled and on my calendar, then
Yeah.
I'm off and everything is
Yeah.
fine. So you're leaving, are you leaving this week or are you leaving next week?
I actually leave this week.
Okay.
Yeah, I'm heading up to San Diego later for my appointment, my medical appointment tomorrow.
Oh,
Get
and
my
then you're gonna
hair done,
leave.
get my nails done.
Important things, right?
Yeah.
And
I do have
then-
2 IPMs in the afternoon though, but yeah.
And then
I
you're
fly out
going
Wednesday.
and then you're gonna leave and fly out from there. And oh, that just sounds fun. Well,
Yeah.
and you haven't really been able to do anything fun since you've been recovering from your surgery and then from, yeah.
There are
every-
days I mean, I go outside of my balcony every day, but there are
Oh,
days
where you don't go outside. You're saying where you're.
I haven't even left my condo sometimes except to go outside of my balcony. Yeah.
Well, and that was the one thing I thought, if you lose your little walking partner, right? Your little walking buddy, because
No.
that got you out, right? Because you had to go out and otherwise you could get completely consumed with everybody,
Yeah.
everything that you have to do, right? And not stop. Whereas that kind of was your, okay, let's go out and walk, right? You have to
Mhm.
walk me. So
Yeah. And I mean, morning and night, and then not many times during the day, and
you walk 4 or 5 times a day usually, right? Together. Yeah, that's what
Yeah,
Snickers. That's
yeah.
what I thought.
so yeah, my routine is off for sure. Yeah.
Mhm,
Yeah.
mhm.
But when I knew your meeting was coming up, I thought I'd be able to attend it. But the brochure times are East Coast, it starts at 11, which means I'm already in my presentation bright and early. on
Oh,
that.
that's right, because you had a presentation. Well, and that was the one thing, even Dr. Burkett told me, don't forget to plug your own meeting after you do your talk. And of
Mhm.
course I forgot. I did my talk and then I thought, oh my heck. And I didn't just have my districts there. The countywide meeting is for all school districts.
Wow.
And I completely forgot to plug my own meeting that they
Yeah.
are all able to attend, because I do that kind of as a marketing or an introduction. Us if you don't work with us currently, but you might want to look into it. And I forgot to plug my own meeting. I was like,
Yeah.
oh my
No,
gosh.
I know. Yeah. There's something else I was going to say. Because aside from being asked to speak for Dr. Burkett a year and a half ago, I've never been able to get through to her
They
again.
had an attorney do reasonable accommodation after me. Between
Okay.
you and me, I thought he was terrible, but I did
Oh.
keep his syllabus for you. But you're right, he's an attorney that all the HR folks use.
Oh.
It was called Accommodations, Jordan Belbisi. And the
Hmm.
reason why I knew him was he came to an IPM that they did on their own with him at Alpine that walked themselves almost into a lawsuit. It was one of the worst IPMs I've ever been to, because they had 3 union reps there and they were so pissed. They asked me we met. Things just went south from there. They asked Yvette to stay, Rayanne to stay. They asked me to leave. Jordan stayed because that's their counsel, but they were
Mhm.
so pissed.
Mm.
But yeah, so he did the accommodations piece. So I thought, well, and I thought it was terrible. But just between you and me, I thought he doesn't really concentrate on schools. He has all kinds of clients, private clients. He's an HR expert,
Yeah.
and you know what he does, employment law.
Yeah.
But that is not like, he's not really. I was just so shocked. I was like,
Mm.
oh, you would have been so much better of a
Oh, thank you.
presenter, I thought,
Yeah.
than him.
Yeah.
And he's approaching it from a legal standpoint too, but the reason what I was going to tell you why I remembered him is because he's the one that told Alpine, because I try not to get involved in legal
Yeah.
advice. He told Alpine, if you can imagine, that that the superintendent, he told him this, that they did not have to pay out the employee's leave. if they couldn't accommodate and they put him off, that they could just terminate him. And I said, stop. Stop, because you need to talk to the JPA civil, you need to talk to somebody, because
Yeah.
nobody does that. No districts do that. What do you mean? All of his sick leave and vacation and his 100 days. He had told them, yeah, you can just terminate him today. And I told them, oh my gosh, you're going to get sued. You cannot do this. You know, he still has employment rights. He still has leave rights. You can't just terminate his leave. And he
Wow.
brought it up in this meeting because he said he had to go get legal advice. And then he finally told them that he was wrong and that you can't do that. So I thought, note to self, don't pay attention to anything he says, because
Wow.
you know, but he's the one that they use to do the presentation. So, because the company is called a partner at F3 Law.
And this
You
is
know
just
what?
last Friday?
Yes. And you know what I was left with, Deborah, was I would never recommend him. He's not on our JPA panel, because obviously when he did that, then I thought ed code wise and school district wise, he doesn't know what he's talking about,
Yeah,
because you
yeah.
cannot do that. And then I told Alpine, stop, talk to somebody over in civil, talk to Julie, talk to Randy Winnett, talk to somebody else. Because then I thought, you know who he is? He's their advisory HR council, because a lot of them have their home. He's their
Yeah.
employment advisor. And that's what he told the superintendent at Alpine, they could terminate this employee. Thank God they didn't do it, because I was like, I said, I'm not
Yeah.
an attorney, but I'm raising the red flag. I work
Yeah.
with schools. You can't, nobody does this. You
But
can't.
I mean, just from a practical standpoint, that's earned leave.
Yes.
I mean, I know the
Belongs
100
to
days
him.
is something separate, but
Belongs to him. I said, if you want the
Yeah.
union to go crazy, and the union went crazy, right? And then,
yeah.
and you know what happened? He went back to the doctor. He got a full release, and he is sitting at work today as we're talking in Alpine. He worked his way back out of where he was, because they weren't going to accommodate his lifting over 50 pounds. But
Yeah.
Yvette got brought to school, because you know what she did? She did the IPM by herself, and she doesn't really know what she's doing. And then they
Okay.
had this guy. Oh, this guy was in the IPM, and this guy was advising them. And I told him, I don't think bringing your advisory attorney is a good look for your first IPM meeting.
Yeah.
That set a tone. And then the second IPM meeting, 4 union reps came, and then things got real, right?
Wow.
Because they weren't having it. So I told her, this is not a good way to learn, but you did learn a lot,
Yeah.
because they brought him to the IPM meeting.
Well,
But you don't need to be that aggressive, right? From the
No,
very
no.
beginning. So, and it was, the IBM meeting was really like how we're getting rid of you, right? That was what the meeting was all about, wasn't? And he didn't do it right anyway.
Wow,
And
wow.
so I was just like, but I did I sat through his presentation, because for you and me, I was interested. I said, I want to see if this is better than what I've seen from him before. But I thought, oh, it's too bad. But I guess he's a popular, a lot of the districts used him as advisory council. And so
Really?
that's why they asked him to speak. I didn't
Wow.
think much of him just because of that one incident, what happened. That lost a lot of respect in my eyes.
Yeah.
I
Well,
was not impressed.
gosh. Yep.
Because that's your
Okay.
legal counsel, right?
Pardon?
That's your legal counsel. That's your expert. That's supposed to be your expert that's helping you, right?
Yeah.
Not walk you into something terrible.
Yeah. Well, when I get back, and I've got a busy month of trainings and presentations, and so I've got a lot to do. But
So you're
and-
changing your website? Did I get that? Are you updating it, or you're
no,
putting
the
a new
website's not changing. It's just my
Oh,
scheduling.
your
platform.
your schedule tool, you're saying?
Yeah,
Okay,
yeah,
getting a new
yeah.
tool. Okay.
So, yeah. So, okay. Well, very good. Another great day, and we'll do our thing on our end. And
Yeah, have a great time on your trip. Have a lot of fun.
thank you. Yeah, I'm looking forward to it.
It sounds
Okay.
super fun.
Take care.
Bye, you too.